Good morning, sir.
Good morning. I would like to reserve 3 minutes for
Yes,
rebuttal.
3 minutes, most definitely.
I am Peter Trinke of the Franklin County Bar, and I represent Scott N., the father, in this appeal of a termination of parental rights.
Yes, sir. All right. Glad to have you with us.
The previous cases we have seen have sort of segued into this. We're fighting about money initially, then we're fighting about money styled as an emotional entanglement. And now we're strictly fighting about human relationships. And my client is the father of Yancy N. He has dealt with a series, and in these juvenile court cases, generally we have parents that have a mental health condition that has not resolved at the time of the opening of the case, and they usually also travel under an alcohol and drug umbrella. So my client is no different than an average client in this case. His biggest unresolved problem was his legal issues. He was incarcerated for his past behavior, not so much his current behavior. But that put him in a position when it came time to perform relative to his child. He was not able to, because there are not any services you can achieve in jail. And when the time he wasn't incarcerated, he was not able to line up services that would run for an extensive period of time, because they said, well, it looks like you're going to go back to jail, and we don't want to waste our resources on an individual that won't be able to complete our program. And so this is the position he was in. And this case is basically an argument about best interest. Because while I can argue against most of the grounds, the ground that the department's attorney discovered at the last minute, that he was serving a sentence of greater than 10 years, is, that's a black and white finding. And there's not, I don't feel like it'd be I feel like it'd be a waste of the court's time to argue against that ground. And so we need to turn our focus to best interest. And these best interest measures look at what have you done with your life to make it worthwhile for this kid to have a parent-child relationship or some sort of relationship with you. And being in jail basically sobered him up. And he had housing. He always had housing because he was a caretaker of his elderly parents.
But he was released from incarceration only a few days before the trial.
That's correct, Your Honor. And so
we really don't know what he's done with his life since he's gotten out of jail, or, there wasn't an opportunity to learn that.
all we know is his announced intention, and that's all we got. That's all he's got. Even if I knew what he was doing now, I could not bring it before the court. So this is what we have, and a lot of these tests are looking at what's the likelihood that this person is going to turn this around, and that we do not know. What we do know is that he was, by court order, he was not allowed to have contact with his child, but it appears from his testimony indirectly, because he admitted to doing activities with the child that would only have been doable at the child's age after the no contact order. And yet when this was pointed out to him, his attorney advised him to take the Fifth Amendment so that he wouldn't be thrown back in jail for contempt of court. So that put him in an awkward position where he cannot testify as to his relationship with the child other than his inadvertent testimony that the two favorite things that he did with this child were basically assembling and disassembling items. I'll call them gadgets because that makes it a little easier to visualize, and also cooking. And later in the hearing, and the foster mother who testified to this had no way of knowing that my client said this, said these are two of the child's favorite things. And so we can infer from that he had a relationship with the child. It wasn't a legal relationship. It wasn't legit. This was just part of the mistakes of his life, as it were. But he tried to stay involved in this child's life, and this child has a significant connection with him through these activities that this child has a propensity toward, that he may not find anybody else in the whole world that can relate to him on that level.
Which activities are you referring to?
The disassembling and constructing items and cooking. And the foster mother had testified that these are two things his child, and it's a fairly young child, and so it would seem odd that just out of the blue he would have these interests. And that is the foundational basis of my argument, plus what my client has testified that he plans to do in the future. And DCS never went to the home to verify the home as being adequate for the child. When they did go to the home, they said that, well, your client has said he's living in the garage. Well, he's living in the garage because, and he would continue to live in the garage because he doesn't want to disturb the occupants of the house, but it's something he could change. So they never went back to verify that the house might be adequate as a place for this child to live. So my client's position at trial was he stands ready to start working the permanency plan to achieve these things, to get his life back on track and become a part of his child's life. And for that reason, I don't think we have clear and convincing best interest. And that's the nature of my argument. It's a simple argument. If you don't have questions, I don't have much else to say.
To what extent or how many months does the evidence establish that the father and child had the time to do these activities together?
Well, the evidence doesn't establish it because he did not, he would not testify to that, but there was a gap of, and I'm because I didn't anticipate this question, was a gap of in between incarcerations. That time in between incarcerations, one could infer from what he said that he was, before the child went into custody, that he arranged with the mother to spend time with that child. And if you look at the findings against the mother, it would indicate that she would consider that to be convenient because she didn't have as much interest in the child as she did other behaviors. And that there's no way we can define that. There's no way he could testify to what that time period was.
Thank you, Mr.
So he got out just before the trial. He got out of prison or jail.
Yeah, he's out of jail. He's still on probation, but
So he has no other impending incarcerations at the time of the trial.
As long as he doesn't violate his probation, and I don't know if he indicated in testimony, so I cannot assure the court that he has had enough of jail. But he did not admit to contempt of court, which would have incarcerated him.
Thank you.
Thank you, Your Honors.
Thank you, and we'll hear from you further on rebuttal. Ms. Moen, or Moen, forgive me if I've mispronounced it.
Good morning, Your Honors. It's Courtney Mohan.
Mohan,
yes,
thank
like
you.
Han Solo.
Glad to have you with us today.
Again, my name is Courtney Mohan. I'm from the Attorney General's office, and I'm representing the Department of Children's Services today. This is a case about a child that deserves permanency and a father that did next to nothing for over 4 years in order to regain custody of his child.
Ms. Mohan, we're working on the version of the statute that requires willfulness to be pled as an affirmative defense.
Correct.
And I don't think there was an answer at all filed here, was there?
No, I don't believe that there was an answer that was filed prior to the trial in this case.
So was there some announcement made in opening statements that, hey, we're going to assert willfulness as an affirmative defense?
There was not, in my review of the record, that there was not that statement made. It also did not appear that during the trial or in closings that statement was made in some way to, have that defense tried by consent. So it's our position that they've waived that defense.
I had a little difficulty following father's incarcerations between the initial, well, I don't know if this is initial removal of the child, but when the child was removed in 2016. Can you step me through those?
I can. That is in Exhibit 9, which was introduced in the record. And in that exhibit, let's see. In that exhibit, we look at page 9. It's a 10-page document. Page 9 is where we start with 2017 was the first period of incarceration after removal. There was a period of incarceration for 3 days for domestic assault. That was in May 2017. Then in July 2017, there was one day of incarceration for a violation of probation. Next, in November 2017 through January 2018, we have 58 days incarceration for the domestic assault. It appears that he was sentenced on that, and so that was to serve his 60-day sentence. Next, he is out of custody for essentially the entirety of 2018, most of 2019. He goes back in to jail in November 2019 through December 2019 for 44 days. That is for a DUI, the domestic assault, which it was unclear if that was a second one, if there's some period of probation also on the domestic assault. There was also a violation of probation that he was in custody for during those 44 days in 2019. Next, the father is out of custody for a little less than 2 months before he goes in February 2020 through April 2020 for 78 days. That is for a failed drug test. The father is then out of custody for about 3 months before he is arrested on a probation violation in July 2020, and he remained in custody on that for just over 200 days until I believe it was about 12 days before trial that he was released.
Thank you.
So in this case, there are 2 reasons why the court's termination of parental rights should be affirmed. First, there are 7 alternative grounds that established that father's rights should be terminated. And secondly, terminating father's parental rights is in the best interest of the child. As there's 7 grounds, and I have about 11 minutes, I'm just going to focus on a few of those grounds before turning to best interest. The first of which is substantial noncompliance with the permanency plans. Here, the father's permanency plans focused on a need for substance abuse treatment, visitation with the child, and generally gaining stability. In 2019, the component of mental health treatment was added. The father was substantially non-compliant with these permanency plans in the about 4 years since removal. I should note that in 2017, the court restricted the father's contact with the child due to the father's lack of compliance with the permanency plans, and stated that if father could establish compliance with the permanency plans, he could move the court to regain visitation with the child. But the father did not comply with the permanency plans and did not move for reinstatement of visitation with the child. Likewise, the father did not complete substance abuse treatment. He made, it appears, one effort to try to get into family treatment court back in, I believe it was 2019, and he completed assessments for that, which did recommend extensive treatment. But the father was eventually incarcerated. I believe it was for a DUI, and he was rejected from that program. Other than that family treatment court, the father made no efforts to try to establish any sort of treatment for substance abuse. There was a drug screen in 2020 that also showed that there was a need for substance abuse, as it was positive for methamphetamine and other substances. Since 2019, when the requirement for mental health treatment was added, the father did not do anything to try to comply with any sort of mental health treatment or seek mental health treatment. He himself admitted that he had diagnoses for bipolar and schizophrenia, and that he needed treatment, but he did nothing to try to gain that treatment. The father also did not establish stability during the over 4 years. As mentioned, he lives in the parents', or at least at the time of trial, lived in the parents' garage and had been there, it sounds like, for some period of time, at least during this custodial episode whenever he was not in jail. It appeared to me that the garage may be a separate area from the house and it might not be a connected garage. But regardless, it appeared that the plan was for, if the child were to return to father, the child would live in the house with the grandparents who were of bad health and could not care for the child. Father even said that his parents would not be able to help with the child due to their health conditions. So effectively, the child would be living in separate quarters from the father without an adult to be able to help the child. And this is a young child that we're talking about. Further, the father has a history of work in a variety of different trades, and he failed to establish any sort of meaningful employment during the about 5 years since removal, and any such employment that could support himself and the child. And I do want to note that since the removal in 2016, the father had been in custody, from my calculations, about 400 days total. But he was out of custody for 1,200 days, just a little bit over that. So that's 3 times the amount of time that he's in custody that he's out of custody, and that he could have been making efforts, but he failed to do so. As such, the father was substantially non-compliant with the requirements of the permanency plans. Looking at the ground of failure to manifest an ability and willingness to assume custody, the father lacked both an ability and a willingness to assume custody of the child. As I've mentioned, he did not have suitable housing. He did not have appropriate employment and income to be able to support the child, and he even testified at trial that he was not in a position at the time of trial to assume custody of the child, and he needed time to get on his feet. But he had 1,200 days where he could have made efforts, but instead was in and out of jail. The father also lacked a willingness to assume custody of the child. He did nothing to try to regain visitation of the child since that visitation was restricted back in 2017, and he did not make any progress on the permanency plans. As stated by the trial court, the father, since 2017, has failed to take one significant step towards addressing the issues that separate him from lawful contact with the child, and the right to such contact was lost over 3 years earlier. Looking at this this information next to the consideration of substantial harm to the child's welfare, the child is doing well in his foster home, and it should be noted that this child is one that needs services. He has ADHD, a developmental delay, PTSD. He needs services, he needs transport to the services, and he needs a support system that's going to help him get to these services in order to thrive. His foster family does that for him, and they provide him with transportation, even rearranging their work schedules and working closely with teachers to make sure that the child is receiving all the help that he needs.
Do the foster parents hope to adopt?
They do. They are hoping to adopt the child in this case. The father, on the other hand, has not even shown that during those 1,200 plus days that he's out of custody, that he's made really any true effort to be able to assume custody of the child. I also want to discuss the ground of abandonment regarding wanton disregard. The father was incarcerated for about 9 days prior to the filing of the termination petition, and his conduct prior to incarceration exhibited a wanton disregard for the child's welfare. Notably, one of the father's convictions in his criminal history is a felony child abuse conviction in which the child that we're discussing today was the victim. That was in 2015, just prior to removal. The father also engaged in conduct that led to probation violations. He had arrests for domestic assault and DUI. He had substance abuse issues that he did not seek to resolve, and those issues are laid out in the dependency and neglect petition, which describe his excessive alcohol use, and as shown in his drug use. The father, during that time, prior to his incarceration, before the termination petition was filed, did not really engage in any way with the permanency plans. He did not do anything to establish that he was willing to take custody of the child. And for these reasons, looking at all of these circumstances, the father exhibited a wanton disregard for the child's welfare. And for these reasons, these grounds should be upheld, and I'll rely on my brief for the remaining grounds. In the last few minutes, I'd like to discuss the best interest factors. There's 9 factors, but there's some key highlights that I believe are important for the court to note in this case. Number 1, this father lacks a relationship with the child. He has not seen the child since about 2016. That was about 5 years or so by the time of trial. He has no relationship whatsoever, no meaningful relationship. The only possible relationship that the father has pointed to is the building of toys, but as noted by the trial court, that seemed to be an odd description of his interactions with the child given the age of the child at the time the father was supposedly interacting with the child. The father lacks any sort of stability to be able to assume custody of the child. He had, again, over 4 years to make any sort of notable improvements, and he failed to do so. As I've mentioned, this is a child that does have medical needs. He needs services. He needs help, support, guidance. He needs someone who's really going to put him first and prioritize him. And the father failed to do anything during the custodial episode to prioritize his child. This is a child that needs and deserves permanency, and termination of the father's parental rights is in the child's best interest. He is in a foster home that does wish to adopt him, in a home that is supportive of him. And for these reasons, this court should uphold the termination of father's parental rights. And I believe I have about a minute and a half left if there's any questions.
You can save that for another argument.
Thank you for your time.
All right, General Mohan, thank you. Mr. Trinke?
Your Honors, the permanency plan requirements that were addressed, one of the permanency plan requirements is resolve your legal issues. And generally, that's primary requirement until that gets done, because as the state's representative indicated, he enrolled in a program and he could not complete the program because he was going to be reincarcerated, and that was the finding of the program. So he sought assistance in meeting the requirements of permanency plan, and he had to do them in sequence. First thing, resolve your legal issues, because you can't do anything else while you're incarcerated. So when the state argues that this child needs permanency, there are other permanent opportunities such as a permanent guardianship that still allows the father to have the right to have contact with this child, even if he never fully rises to the level to be a full-time parent of this child. And because of the child's condition and the child's propensity to be able to connect with the father, this is an outcome that we should look at rather than terminating the father's rights, because this child is going to have no way to connect with any individuals that match his genetic predisposition for behaviors. So to terminate rights and sever this relationship when this child already has some destabilizing factors will deprive the child of an opportunity to have a relationship with an adult that completely gets him and can communicate him on levels that are genetically determined. And that would be the basis of my argument, unless you have any further questions.
Hearing none, thank you, Mr. Trinke and General Mohan. We appreciate your oral arguments. That concludes this case, and we'll take it under advisement. Mr. Trinke, a point of personal privilege, how is our former colleague, retired Judge Chancellor Jeff Stewart? Do you get to see him or hear of him?
No. Actually, I'm from Franklin County.
Okay, so. All right, well, good. Well, all